Good morning or late morning, 11 o'clock, November 16th for the Mobile Home Task Force meeting. The agenda is posted. Also, there's some documents which might be referenced during the meeting on the on our website. Also on the website, I wanted everybody to know that I've been putting, after each meeting, I do put up a document with links to various points in the meeting for each subject matter. So that if you're interested in a certain point that we talked about during a meeting, you can go to those documents. They're under my name, Representative Kurt Taylor, and they have individual links to the subject so you don't have to spin through the whole video to pick at the part you want. So we'll get started pretty quickly today. We've got Senator Harrison is here, and in the room is our attorney, Jonathan Gray, and Patrick Monk, who's going from DEC, and Polly Mason from VHCB. Sorry. You can't quite see her, but the other two you can. Anyway, okay, let's get started. Our first agenda item is the introduction of our new attorney, Jonathan Gray. If you want to say a few words before we begin.
Morning, everyone. John Gray, it's great to be here. I'm stepping in. Thankfully, Eric Fitzpatrick has been covering. He took over after David Hall left earlier this year. I've taken pieces of David's portfolio, including the housing piece, which is why I'm in this particular committee. I'm super excited to be here. Housing is an exciting topic. And with that, I'm ready to go. Happy to answer any questions if you guys have questions regarding background, but mainly just excited to be here, and I'll do what I can.
Okay. Welcome aboard.
Thank you.
The second item is the quick review of the agenda. Our first topic will be the Department of Environmental Conservation. DEC is going to talk a little bit about the revolving loans. There's been some concern as to their availability for mobile home parks as opposed to municipalities. So we're just trying to get some information on the revolving loan funds for drinking water and wastewater, which are a wonderful asset for financing infrastructure, which mobile home parks have a real difficulty with. So we'll cover that. And then at 11:30 from the Secretary of State, David Hall will come in, and he's going to go over the types of businesses that mobile home parks, especially cooperatives, can use in their formation. This is because I went in and went into the registry, the Department of Housing and Community Development Registry, and started looking up some of the businesses to see in the Secretary of State's website to see what kind of businesses actually run the parks or own the parks. And some of them, it's a real mix. And a lot of them, I don't understand what they are, the difference between a limited liability corporation and a C Corp and sole proprietorship and all that. So he's going to go over that a little bit before our break. After the break, we're going to zero in on charge 3, which has to do with the question of whether a mobile home is real estate or personal property. That was one of our charges. And we've pretty much wrapped up that issue, and members of the committee have a document, which is what we will give to the attorneys to help them writing the final report. And I want to really look at that closely and figure out whether the recommendations are good recommendations, whether the findings are accurate, things like that. So we'll clean up charge 3. After that, we'll go over a document which I've sent out to all of you, which is the larger document for all of the charges. And I don't want to get into that in detail. I think that would take too long, and you haven't really had a chance to look at it carefully yet. But I wanted to skim through it very quickly and just so you know what it is. We'll be going over that. Senator Harrison and I will be going over that individually with members of the task force to get verification on things, and maybe there's other recommendations. So it'll change a lot before it goes to the attorneys. And finally, at 1 o'clock, Jeremiah Ward is going to come in. He's on a tight schedule, so he's going to come in at 1 and talk to us a little bit about some questions that I gave him for the last meeting, which are on the website under Cooperative Development Institute, under the Reports and Resources tab. Some of that information he's covered a little bit, so he can kind of skip over some of that. And I had a couple other questions for him just to clean up some of the issues that were left over from last time. And then we'll go to next steps. And but we have one more meeting. And that's kind of the one that's December 16th, which will finalize the report, the report information we're giving to the attorneys. So with that, we'll get started with DEC. And Patrick Monk, you want to introduce yourself for the record? And
Sure. Good morning. My name is Patrick Monks. Just a quick note on the agenda, there's an S on the end of my last name. I'm the program manager with the Water Infrastructure Finance Program. We are part of the Water Investment Division at DEC. And thank you for having me this morning. I'm happy to provide an overview of the state revolving loan fund programs. And then I don't have a formal presentation. Happy to focus on these specific areas of concern or interest you guys might have. Just to quickly start, the state revolving loan funds, I'll refer to them as SRFs. We have there's two primary ones that I'm talking about, one for clean water, one for drinking water. They can and are used by some MHCs for some of their clean water and drinking water infrastructure. Our program offers low and no interest loans. Technically, all our loans are zero interest. We do charge administrative fees that are, they're annual fees, and they behave just like interest. So for all intents and purposes, I'll call them interest. Interest rates run from 0 to 2.75%, depending on some of our loans are also offered with principal forgiveness or subsidy. And that's one of the probably main draw points to our program is our ability to forgive certain portions of certain loans. And I'll get into that in a little more detail, but those limits are established by EPA as part of the federal grants we receive from them each year. So again, we've got two programs, clean water and drinking water. When I say clean water, it's primarily wastewater. On the clean water side, we primarily fund municipal projects. We do fund some private projects as well. All projects that we fund need to have a clean water benefit, a demonstrated or demonstrable benefit to surface waters. Private projects have more limited eligibility under federal guidelines. They're limited to what are referred to as non-point projects. A typical non-point source pollution project might be something along the lines of a stream bank restoration project, but it can also include failed on-site wastewater systems because there's no point source for that wastewater to get to receiving waters. It's just distributed into the ground. So I will be talking about one of the projects we have funded, and their wastewater system fell in that category. On the drinking water side, we fund public drinking water systems. That term is a little misleading in that it includes private drinking water systems. So public water systems include a lot of different things, but in terms of MHCs, that would be an MHC that has either 15 or more service connections, drinking water service line connections, or 25 or more year-round residents. Under both programs, we fund all steps of projects, planning, design, and construction, and typically projects that are coming in for funding move through that sequence. Coming in, first getting their planning loan, developing a preliminary engineering report, moving to design, and then ultimately construction. One relatively recent example of a project we funded, and we don't have a lot of MHCs coming in for funding, but certainly, and that's also true for some of our smaller communities and smaller drinking water systems that are not MHCs. Vermont has a preponderance of small systems, more so or close to, having the most, sort of smaller systems per capita compared to other states. Yeah, happy to pause for a question.
Yeah, I just want to confirm that MHC is mobile home community. Is that right? Or something like that?
I'm really sorry to start with an acronym. I thought walking into this community, I thought that was sort of on the title. Yes, yeah, manufactured home community or manufactured housing community.
Manufactured housing community. Okay, great. Well, because members of the public are watching this too.
Great, thank you.
Thank you.
So we had a project, the Milton MHC. They received funding under both clean water and drinking water to do some improvements to their drinking water system, and they replaced I believe, a failed on-site wastewater system. That system was connected to the municipal wastewater system. On the drinking water side, they recently amended their loan to increase their funding by an additional $200,000. On the drinking water side, that's $1 million loan, and half of that loan will be forgiven. It's been awarded subsidy. On the clean water side, there's a $500,000 loan, and there is no subsidy there. That's an important point. Under sort of long-term practice policy on the clean water side, which I believe is influenced by state statute, and I wasn't around for when clean water funding evolved into funding private entities. We do not offer subsidy for private entities on the clean water side. We can on the drinking water side. We can offer loan forgiveness for private entities on the clean water side if that loan is municipally sponsored. But certainly that is an area of interest. We've received feedback. We have a sort of public comment period every year, which I'll get into as part of our overall funding plan. And we certainly received input, urging us to consider a revision to that policy so private entities can receive subsidy. I do note that under state law, we do need to provide overall funding assistance to municipalities first on the clean water side before we move to private entities. So I know it's hard to not to dive too deeply into the details. I'm doing my best to try to sort of keep it big picture for now. So in terms of how our program operates and what funding we have available, we follow an annual process. It more or less starts with us applying to EPA for annual grants. We used to receive one drinking water grant and one clean water grant. As a result of the bipartisan infrastructure law a couple of years ago, we now receive 3 separate clean water grants and 4 separate drinking water grants. Makes it a little more complicated, but at the end of the day, it has resulted in an increase in funding. Those grants range anywhere from, in past years, roughly maybe 6 to 12 million per program. Last year on the drinking water side, the grants added up to 46 million. Big chunk, or even most of that money on the drinking water side is dedicated towards replacement of lead service lines. That's a big part of the bipartisan infrastructure law. As a requirement of receiving that grant, we have to provide a state match. That match ranges is anywhere from 0 to 20% of the federal grant that we receive from EPA. Those funds, so the grant funds from EPA, any match funds that the state provides, plus our repayment funds are made available to projects. Repayment funds gets to the revolving nature of the program. Federal monies come in, they're loaned out, they're repaid. Those repayment monies are made available to future borrowers. And as a result, the body, the funding, the overall amount of funding has grown over time. We present this plan to EPA and to the public in the form of what we call our intended use plan, or IUP. It spells out all the various funding sources, how the uses for those funds, subsidy categories, and also includes a project priority list. Subsidy categories, again, are important. EPA stipulates as part of their grants the percentage of the grant that can, or in some cases needs to be provided as subsidy. So we don't have discretion to say necessarily we're going to spend 100% of that grant in subsidy. It has to fall within the restrictions that are established by EPA. Within that, we have the ability to say, all right, if we have a $5 million grant and we can provide $2 million in subsidy, we can say we want to reserve $1 million of that for planning loans, and we want to reserve $1 million of that for construction loans. To take it a step further, the grant requirements specify whether that subsidy needs to be made available to all borrowers or to disadvantaged communities. Technically, on the clean water side, we use the term affordability criteria, like a project or community meets affordability criteria. On the drinking water side, it's disadvantaged community. I'll just use disadvantaged community to refer to both. Yeah, so again, the intended use plan will specify, what amounts of subsidy are available under which grants, and whether that subsidy is available to all borrowers or just disadvantaged communities, and the dollar amounts. And the public is available to, able to provide input on that overall plan. The intended use plan also includes, which I just mentioned, the project priority list. Any project that wants to receive construction funding has to first apply to be on the priority list. Projects that are coming in for a planning loan, just for planning and design, do not need to take that first step. The project priority list ranks. We have scoring criteria on both sides. Clean water and drinking water projects are scored against a broad range of criteria to establish their ranking. And the projects are listed in rank order. And then when we have more demand, as part of that priority list application, the applicant estimates their costs that they plan to eventually borrow for. Where that demand exceeds the funds available, we have to draw a funding line. If we've got 100 million in demand, 50 million in funds, we draw that line at 50 million. As projects, we do keep track of projects. They're required to meet milestones to demonstrate that they're progressing. If they don't, then we're able to bypass them and make that funding available to other projects. This year on the clean water side, we had a funding line. We quickly reached out to projects, found out a couple weren't likely to go forward, so we were able to drop that funding line and fund all projects. On the drinking water side, we still have a significant amount of unmet need. As mentioned, we do receive input on the intended use plan, and we definitely received public comment this year urging us to, make subsidy available on the clean water side to private borrowers, some private borrowers. That certainly taken into consideration, and we'll be, contemplating for including that in the next intended use plan, and also reaching out to stakeholders in advance. On that point, I think our program, I've been with the program for 2 years. I've been with the department for quite a while. Just before I started, the program had moved to establish that all cooperatively owned and nonprofit owned MHCs are categorically meet affordability criteria on the clean water side. So they are eligible for that form of subsidy. But again, because they're a private borrower, they would need a municipal sponsor for that loan in order to access that subsidy. So we have been taking steps to, better serve MHCs and other small and disadvantaged communities. Under the bipartisan infrastructure law, we are also required to identify barriers to participation in our programs by disadvantaged communities. We've started that process, certainly have more public outreach that we need to do and intend to do this year. See what else in terms of public comment and what our future initiatives include. It's again, reconsideration of the policy and whether private borrowers can access subsidy on the clean water side. Again, I do note that under state statute, we do need to prioritize funding municipal borrowers over private borrowers. And on the clean water side, also at the federal level, we have eligibility limitations. Again, we can only fund non-point source projects on the clean water side. We also received comments that, to back up, our program is fairly complicated. There are a lot of requirements. Almost all of those come from the federal level. We do have the ability to reduce those, some of those requirements if we, we can practice what's known as equivalency. So basically, we need to, all projects need to meet all those federal requirements up to the amount of the grant dollars that we receive from EPA. We don't necessarily need to apply them to all projects. Implementing that is fairly tricky. Haven't done it. I think we just started trying to do it when I started. We backed off. There were some issues, but that is something we can consider under future intended use plans. So we could say for certain categories of projects, we can reduce some of those, what we call federal crosscutters, things like Build America, Buy America Act. It's a great program, but it also drives the cost of borrowing for the borrower. They need to source almost all their materials from U.S. manufacturers, and there's a range of other requirements. So that's something we can consider, as we move forward. I think that's kind of what I had in mind for prepared remarks. And I do know I didn't have a ton of time to prepare. We're in the midst of a sort of major database rebuild, which and we're about halfway through, and then we've been doing 2 weeks of user testing, and we're in the midst of that, coming out of that right now. So that's kind of all I've been doing for the last 2 weeks. And so when I got this invite on Monday, I was like, okay, I'll see what I can do. That database project does tie into some of these overall issues, and some of the barriers to participation are, relate to, okay, if I'm a borrower, if I'm, a manager of an MHC or an owner or what have you, what is our program? How do I apply? All those things are fairly not terribly transparent. Like if I go to our own website, it's a little confusing. If I start that application process, it's not terribly clear who's going to be involved. What is the status of my application? All those things. So we're working, really hard to improve there. The database is a big piece of it. Our current database is quite old and doesn't do everything we need it to do. And we're required to report all our loan information to EPA, and that used to happen automatically. Because of the age of our current database, that doesn't happen automatically anymore. So we end up spending time on stuff like that versus trying to help our borrowers get through our process.
Okay. Well, I think that's good, and I appreciate you coming in to cover it. We have a few minutes for questions for people who might have some questions. Paul?
You had talked about the requirement to identify barriers for participation under the IIJA, and I'm just wondering, you might be at the early stages, but if you can talk a little bit about what the outreach is going to look like, or if there's a plan in place, or if there's a time frame for developing an outreach plan for that.
Yeah, the time frame is, we're feeling a little overdue on it. Our program meets with an MHC group facilitated through USDA. Mm-hmm. So there's been some initial conversations there. The plan is at this point, as soon as we can get our feet on the ground with some of this database work, is to start reaching out to the groups that we work with and others, and to essentially formulate a plan. So yes, very much in the early stage. The bipartisan infrastructure law requirements are, it's a 5-year initiative. So we do need to be taking steps, but certainly EPA recognizes that it's not something that can happen overnight. But certainly we'll welcome feedback. I think staffing has been the biggest issue. When I started a couple of years ago, we were in the midst of a sort of record spike in applications and operating at about 50% of historical staffing levels, especially on the drinking water side. So we've been way behind in terms of just getting applications processed. So it's been a real challenge to take on some of the new initiatives that have come from the bipartisan infrastructure law.
And the jump from 6 million to 46 million is a pretty big increase in the program. So I imagine
it is
something you're looking at as well.
Yes, absolutely. Yeah, and a big part of the bipartisan infrastructure law, as mentioned, includes the lead service line inventories and replacement. There's a federal requirement that all public drinking water systems inventory their service lines to identify whether there's lead. And there are an awful lot of systems in Vermont, so we're working really closely with the Drinking Water Groundwater Protection Division to get all those systems funded and through that process, so we can move to the next step of replacing them. We take down these grants from EPA, and the next step is we are absolutely required to spend that money. And the lead funding is really large, and the time frame is very aggressive. So that's definitely taken a big chunk of our attention.
Other questions? Go ahead, Senator.
Yeah.
There we go.
Thank you so much for being here, even though it was difficult with your schedule. It's really helpful. It's a super complicated program, or both of them are, but very helpful to the municipalities. If you're able to give us a written version of your testimony, it'd be very helpful, but I don't know if that would be possible. Just a couple of quick questions. Did you say that the funds that are paid back are those stay in the state? Did I hear that correctly?
Yes, they do. Yes, those are repayment funds. Those are, I'd be happy to send down a copy of one of our intended use plans, which are fairly long, but that spells out the funding that's available for a given year and shows how much of it is the grant, how much is repayment funds. There's also interest that accrues on the fund, which is relatively small compared to those other values. But yes, those funds do stay in the state and are made available for other borrowers in these programs.
That's great. And then the being able to reduce, did you call it federal cost cutters, the Buy America Act?
Cross cutters, yes.
That's a huge impediment to a lot of grants for towns. So it's good to hear that, at least in this situation, that has a possibility of being excused.
It does. We can't do it for all borrowers by any stretch. But we can, consider doing it for some. We do have to, in terms of our obligations, to show that we are making what are called binding commitments to EPA. We have to loan out money in an amount at least equal to the grant. And all those projects need to fully comply with crosscutters. If we go beyond that, we can reduce some of those requirements.
I see.
So
Okay.
we can't just, wave our hands and say, we don't have to do that anymore. But certainly, if we're
I
talking
didn't think it would be
this-
that easy.
Yeah, relatively smaller borrowers and this, that are, in a disadvantaged community, that could make a lot of sense.
Oh, definitely. And then, so you said in the drinking water, you could not meet the need, and clean water, you did meet the need. Is that right?
This year, yes. And
Okay.
we may end up meeting, I don't know that we'll meet all of it, certainly meet more of it under drinking water as some projects choose to not proceed.
Okay. And is that the typical spread in a year?
I'm not so sure. The last 2 years have been, and again, I started a couple of years ago. And then we had the bipartisan infrastructure law roll right in. And so that sort of upended all the normal.
All right. So there's no typical anymore. Okay. Well, just thanks again for being here. It's super helpful, and we'll probably have questions as we go along.
Thank you.
Yes, another one.
Holly, go ahead.
We've heard a lot about the ARPA Healthy Home initiative here and how that's benefited parks. And so I'm wondering if that's another program that you work with. If you could talk about how that fits in with the SRF funding.
Sure. I'm not that directly involved. It's an ARPA funded program administered by another division within the department. Most of their borrowers aren't accessing the SRF loan program. It's funded on, it's focused on smaller borrowers. My program was previously responsible for developing another ARPA grant program to help what's called 3-acre sites in the stormwater world. These are existing sites that need to meet new requirements. Part of the grant program that we developed, which is now managed by another section within our division, specifically developed an ARPA-related grant programs to help MHCs with those 3-acre permit requirements, help them with obtain permit, and the next phase will be assisting with construction. Certainly work closely with the Healthy Homes folks.
Okay, I have a quick question. So MHCs or MHPs, are they considered to be private as in terms of the loans? Do they have to then work with a municipality? So the first step is for a MHC that wants to access the funds has to get some coordination with the municipality in which they exist. Is that?
It depends. So, on the drinking water side, if they're a public water system, so, again, 25 or more residents, 15 or more service connections, they can come in without a municipality, they can get loans, and they can qualify for subsidy. On the clean water side, yes, they are private, they would be considered private unless, municipality owned them somehow. On the clean water side, as a private borrower, they're eligible for loans. It's a reduced eligibility sphere, again, just non-point projects. If they, on the clean water side, MHC wants to apply for loan subsidy, then they would need a municipal sponsor. So the municipality would be the borrower on behalf of the MHC.
Okay. And one final question, is there a definition of disadvantaged communities or?
Yes, both our IUPs define them. Generally, it's communities with their median household income is below the statewide average. On the drinking water side, it gets a little more complicated. At both sides, it can also take into account whether the user rates exceed 1% of their MHI, median household income. So it's not strictly speaking just income. But, if the project is going to result in, unreasonable cost burden for the borrowers, then they can also qualify.
Okay. Good. Any more questions? Very good. Well, thank you very much for coming in. You can stick around or you can
I do need to get
back to your database.
Yeah,
And I think
our contractors are after me to complete my testing, so I appreciate you having me. Thank you all.
okay. Thanks again. Next is from the Secretary of State's office, David Hall. You want to
Sure.
join the table? So
Tell me where you would prefer that I sit so that everybody can see and hear me.
if Patrick Monks is leaving, you can switch with him.
Okay, all right.
It's kind of nice to be able to see you on it.
Sure, of course.
Good to see you. Yeah.
The new witness seat.
Yeah.
It's exciting. All right.
Good to see you, David.
Good morning, everybody. For your record, my name is David Hall, not legislative counsel. Here in my capacity as the director of the Business Services Division, Secretary of State's office, which I'm very glad to be here. It's a little bit funny fit for me, so I'm really hoping to be as helpful to you as I can, but understand that my expertise is very narrow in this field, sort of.
Okay.
All right. So what questions can I help you answer?
Well, in the registry, the Department of Housing and Community Development Registry, it takes various mobile home communities and says who their ownership type is. And that is something like sole proprietorship, and there's one that's partnership, LLC, S Corp, trusts. And I don't know the difference between those.
It's listed as, one of them is listed as all of those, or there are separate entries that have various
In that particular
among those?
database, or what I've seen of it, it's all of those in one.
Okay.
I mean, I can show it to you.
Curious.
That's the database entry.
Sure.
So
Okay.
there's that. So what is the difference between a limited liability corporation, an S Corp, and a C Corp?
Sure. Fair. Good questions, all. So I think the most important thing for you to keep in mind when you're talking about business organizations is the distinction between the entity structure itself, which is specified or authorized by usually a state statute. That's what allows you to create something that is other than yourself. It is a separate legal existence. That is the creation side. That is the organization side, the management side. That is the nexus to my office, where we do a formation document and then an annual report for as long as you're going to survive. If things change that we require information about, you file an amendment. If your business ultimately terminates, you file some sort of articles of termination or dissolution that ends the life of that entity. And it's a separate legal entity. And entities are distinct from sole proprietors, right? So we we say sole proprietor and we assign that moniker to basically an individual who is conducting business in their own right. And they do not have a separate legal identity from their business. It's Kurt Taylor, the plumber, and you're just out there in the world versus Kurt Taylor LLC, Plumbing LLC, or just you LLC, which is a separate legal identity, right?
So a good many mobile home parks are owned by a single person
Yep.
who has 4 or 5 mobile homes.
Sure.
That person would most likely be a sole proprietorship.
It depends on how they have organized their legal existence and affairs. So
But if they do nothing,
if they do nothing, if you just went out and bought 5 houses, then that would just be you. And so let me, before I go any further down that rabbit hole, let me say the distinction I was drawing originally is between formation, state structure, organization, et cetera, and then taxation. They are not the same, right? So there are usual things that happen when this, then that, if organized this way, then taxed that way. They are not always the same, but they are different things between the way, for instance, the federal government for tax purposes treats operations and what your organizational structure is. So back to your question, and it's a good way to think about it and give schema on it. Again, if I just went out and bought 5 houses, there are different ways I could structure those relationships, right? I could just own 5 houses. One would be probably my primary residence, not necessarily, and then the other ones may be our investment properties. I am nominally a business, right? I'm operating something to earn money, and that's what we think of as a business. I've made a capital base investment. I expect some sort of return. But the ownership structure, there's no distinction in the identities between myself and these houses. And that is extremely important when things go bad because one of the most fundamental concepts of modern business organizations is the concept of limited liability. So an LLC or a corporation or a mutual benefit enterprise, there are different types of entity structures, and we can talk about all of them, but creates this legal distinction between myself and the business. So if I buy my own house and I'm living at my residence in Montpelier, and my wife and I own that, and we have our own taxation and we're us, but we have a business, we have an LLC that owns these 4 or 5 houses, then those are distinct legal entities. And that means all kinds of things. It means this entity is making its own money. This entity is subject to taxation in one way or another. This entity is subject to liability in its own way. And I can actually structure my ownership so that each of those houses is owned by a separate entity. That insulates the liability, the accounting, the revenue, the debts, the income, the everything, one from another, and from me as an individual. So those are ownership structures. The state allows the creation of separate legal entities specifically because the state wants you to put capital at risk, and it wants you to limit liability so that you will make some sort of investment back, some capital back investment, and then know that the extent of your liability, of your loss, if something goes wrong, is what you've invested in that company. And P.S., you can lose that distinction between your individual self and your entity self if you don't follow steps that are necessary to demonstrate that the entity is legally distinct. For instance, you have to adequately capitalize the company. You have to have more or less separate operational structures, at least to the extent of keeping separate records, holding the meetings that are required by law, having the directors or the managers or the whatever else that are required. The formalities of the construct have to be observed. Otherwise, we can do what's called pierce the corporate veil, and you lose that limit of liability, and people can actually reach through the entity and come after your personal assets. So that's why we set up businesses, is for people to put capital at risk and limit their loss to what they have invested. Taxation is different. So let me take one big step back from a historical perspective. We started off with just individual people owning things, and we sort of moved towards trusts, and we recognized partnerships. And a trust was a way of having sort of a distinct legal existence, but it couldn't last forever because the law frowns on trusts in perpetuity. So for a long time, a trust could own something separate, and you'd have oil company trust, for instance, but like they could only be around technically for 99 years. And after that, the law considered to be a problem. Partnerships were recognized as ways that people could work together. So we would form a law firm, there'd be two of us. The problem with partnerships was that it really disregarded the entity structure and said it's really just two people operating a venture together. And while that has certain limitations, we're still going to give you individual liability. So as the law evolved, we changed things. We moved from trusts to corporations here to allow a perpetual existence of a separate legal entity that could hold property, it could sue and be sued, it could raise capital, and it would use shareholders to do that. So they would have some ownership interest in the corporation, and the corporation would operate a business and try to make money to give back to its shareholders. And then on the partnership side, we realized, this is really great. The good thing about a partnership is that we can have this identity, even though we don't have a limited liability, and we can pass through all the money that we earn, and we can pay that on an individual basis. And that's a big difference between, for tax purposes, a corporation and a partnership, is that a corporation essentially pays taxes twice. So it pays at the corporation level when you earn money as a business, and then it pays at the shareholder level when you pass on dividends or earnings to the shareholders. Partnerships had that benefit of only the single taxation. So even though 10 people could be running a law firm, the firm itself as a partnership didn't have to pay separate tax. It just passed its earnings through to its partners proportionally on whatever basis they chose, and then it was individual taxation. So all this sort of like the best of both worlds, this separate legal structure, this ability to have corporate governance and separate identity, kind of move this way, and the partnership kind of move this way so that we could get the limited liability that a corporation affords. And we came up with what is now called the LLC, Limited Liability Company. And that is the majority of new businesses formed since 1995. It's in some states, probably, I don't know what it is for us, but it's upwards of 85, 90% of all new entities are now organized as LLCs. It can choose whether to be taxed as a corporation. So there's double level, basically double taxation at the two levels, business entity and individual, or it can choose to be a pass through like a partnership and just send all the money through to the owners. They're called members, and they only get taxed the once. So that sort of brings us to where we are on for-profit entities, right? So now I want to talk about nonprofits and co-ops real quick. Is that helpful?
Yes, that would be good.
Okay.
And the more you can get it into mobile home parks.
Yep. We're gonna get there. So you can also have a nonprofit corporation that is organized for some sort of exempt purpose. And if you check all the boxes for purposes of the federal government and for most state taxation as well, you are exempt from tax. There are differences. A nonprofit can own property. It has a separate legal existence. But there's no owners of a nonprofit. And that is that's a big difference. So whereas a corporation has shareholders who ultimately own the company, and if the company went bust, or not bust, if it were sold, shareholders are the people who own the equity in that business. Okay? Nonprofits do not have equity owners. And if a nonprofit dissolves, its assets have to be distributed through various processes, either to another nonprofit or to sometimes to the state, actually. But an individual doesn't get to make all the money and hold all the assets that a nonprofit does if it dissolves. So that's a separate structure than if you set for instance, a mobile home park up is some sort of for-profit entity versus a nonprofit. So now co-ops are even weirder. They started 1800s or so for the purpose of allowing small, basically producers to band together and reach economies of scale when participating in markets. They've expanded to not just be for producers, they can be for buyers, they can be for employees, they can also be for housing. And remember, there's the duality of organization and also taxation. And cooperatives are different in both respects from all of these other things that I've talked about. So a co-op is usually considered a type of corporation, but for tax purposes, you could operate an LLC on a cooperative basis. And that's why I want to keep saying there's a distinction. So for purposes of our laws, the way you would form a co-op, and I'll say that our laws are outdated. And when we adopted the Model Business Corporations Act, we did not update our co-op statutes. And so our co-op statutes actually still refer to the corporation laws that pre-existed the MBCA, and the laws that cross-references don't exist anymore. Might want to be something you guys consider for a bill one day. But anyway, so basically you would form, for the state creation side of things, you would form a corporation, a for-profit corporation. It used to be under 11 VSA Chapter 17. Now it would be under Title 11A of the statutes. And you need to have a board of directors and articles of incorporation that creates it. And you need to have, whatever officers you name. But then the cooperative structure itself is kind of a layer on top of that as far as the organization goes. And to be a co-op, you have to check more boxes. And historically, those included things like one person, one vote. Instead of, one person being able to dominate a corporation by owning 95% of the stock, a cooperative is predicated on a model that each person is equal, even if they own different amounts of ownership in the entity. And under our laws, you can modify that in your articles. So that's a little kooky about our statute, but that's the general premise: one person, one vote. And also the ownership is limited to the members of the cooperative. So it's the people who own it are the people who govern it and the people who run it. And it's for their benefit. There are limitations on how much any one person can own. So for instance, in our statutes, the default is a max of 10% if it has stock. And then there are requirements on, how much business you do can depict, basically govern how much you can get back from the cooperative. But a cooperative is a separate entity also, like it's a type of corporation. For tax purposes, most co-ops are governed under what's called subchapter T, and it's about 8 sections of the Internal Revenue Code that specify all the things you have to do to qualify as a cooperative for tax purposes. And the benefits you get if you do qualify basically are that you have single taxation for most of the money that the co-op makes. A co-op can earn money, but then give patronage back to its members and then deduct the amount that it's basically giving back on a patronage basis and not have to pay tax on that. If the cooperative makes money off of non-patronage activities, it has to pay taxes on that. And the single taxation occurs at the patron member level, where once you give those distributions back to the patrons, they pay individual tax on what you give them back to them. So for mobile homes, one more layer, 11 VSA, is it chapter 8, 7 is the Cooperative Housing Act on our books. And that prescribes its own overlay of how you can set up a housing co-op. And in that circumstance, the co-op itself owns property. The patron members are owners of the co-op, not of the property. They have an ownership share in the co-op itself, but the co-op owns the land, owns the buildings, and you basically pay for the right to own part of the co-op, and you get a proprietary lease to use one of the units that the co-op owns. And you can get the same tax deductions as an owner, but you don't actually own the property. So that's what a housing cooperative is. And it's different than a condominium and also a common interest ownership community in important respects. So think of those three models of housing together. Let me say them again. So you have your housing cooperative, you have a condominium, and you have a common interest community. It's not a condo. So in a cooperative, again, the co-op itself is the legal entity that owns all the property, and the residents own shares in the co-op. In a condominium, it's real property that an individual person owns. They own a unit, and then they also own a proportional share of the common property. And then in a common interest community, the unit owner owns the property, and then an association owns the common property, and they are members of the association. That's a lot. I fear that in all that general explanation, I lost the thread of now being helpful to you and what your specific question is.
No, that's good. One of the essential questions I'm trying to figure out at the moment is who decides with a cooperative or with a mobile home park, which is not a cooperative, an LLC owns it, or a nonprofit. Who makes the decision as to how the money is spent?
That's a great question.
Who's the budget
Yep.
and the lot rents are the two things that I think of. Who decides that?
That's a great question, and it is one of the fundamental distinctions between every different entity type is the governance structure. So the reason that we have the statutes that we have is we say as our bargain with individual people in the world, we will allow you to form this entity, and we will allow you to put capital at risk on a limited basis in exchange for you structuring yourself in a way that conforms to our law. And our laws are different levels of prescriptiveness on how much entities can deviate from what is the standard construct, right? An LLC provides the most flexibility, I'd say, in setting up your affairs among your members. A corporation is much more prescriptive by law of what you have to do. And part of what the baseline or the sort of the default is relative to what you can change is governance. And each entity has its own governance structure. So for all those things that you mentioned about who owns this part, well, if it's a sole proprietor that has no separate legal identity, there are literally no limitations that I can think of what they do with the property, how they spend the money, how they alienate it, how they encumber it, restrictions they put on it. I mean, there may be like fair housing laws that would apply, but as far as governance goes and what you do with the land, it's your property. You do what you want with it, right? If you are a pure corporation, you are governed by a board of directors which oversees executive management. Board of directors are elected by shareholders, the owners. So shareholders, the owners elect a board. Board oversees the management by an executive. Generally, the executive makes the decisions on how the money is spent, how it's invested, what you buy, what you sell. The board is overseeing the executive management. If they don't like it, they can kick management out. If shareholders don't like what's happening with the direction of the company, they can change the board of directors. That's how that works. For a co-op, it depends on what kind of co-op it is. So for a housing co-op, for instance, you have to have at least 3 directors. 1/3 of your directors can be non-member owners, but only 1/3. So essentially, if the housing co-op, this is a type of corporation, again, with these layered requirements over it, it would be governed by its board of directors, which may be 3 or more members. Always at least 2/3 would be member owners, and they would be the ones making the decisions along with their executive leadership on how they deploy their capital, spend their money, whatever.
So they don't present a budget to the members or anything? The budget is not voted on by the co-op member?
It depends on how it's structured. I mean, it could be sent out to the membership. Remember that the members are the board and the board are the members and the members control the board. So even if the board did have, let's say, 3 directors and 2 of them would have to be members and then the third person would be selected by the members. It could just be a non-member. So they are very much in control in how the board and the executive management should act. They are the member owners. That's the point of having a co-op. If you're an LLC, you can structure it a lot of different ways. There are several kinds of LLCs, but from a management perspective, we usually divide the world into member managed and manager managed. But you can write your operating agreement to sort of set it up however you want it to go. And there are default statutory rules on what provisions of an operating agreement, for instance, you can change. Basically, it's to protect minority interests. Like you can't take away people's rights or impose money, like special fees on them, for instance, without their assent, usually. But otherwise, majority rules is sort of the way entities run when there are private and there are owners. But you can structure that any way you want to. And, well, we don't need to go into partnerships. I will say we also have an entity type called a mutual benefit enterprise, which was originally called a limited cooperative association, and that was intentional. And it is a next generation sort of model of a pseudo cooperative in which you can actually have non-owner members called investor members who, along with patron members, own the company. But patron members, the member owners, by our statute, by law, are always required to have a majority of the controlling interest in that entity. And what this allows you to do is to give an equity stake to investors without losing control of the company. So if a co-op is generally one person, one vote, usually only the members own the company, they're the ones controlling everything. It can be hard for co-ops to get outside investment because they don't have an equity interest to offer. And there are limits on what the company can return to non-members. An MBE or an LCA, again, allows you to have this construct where always 50.1% of the board of directors will be elected by the patron members. They have basically always a majority say in how the business operates, but it also allows investor members to have an equity stake and ownership interest in that business, to have seats at the table, but not be able to control it, which is sometimes what happens in corporations or LLCs. Does that answer your questions on?
Yeah.
I mean, it could be simpler, right?
Okay.
There could be fewer entities.
No, so other questions from other people?
Hi, David.
Hi.
Nice to see you.
You too, Senator.
So I guess it's funny because I was working with co-ops a few months ago, and one comment they had was that was the only business type that wasn't on the website, and now I see why it's not on the website, I guess, because it's just really complicated, or at least that you couldn't apply to be a co-op on the website.
Which website?
The Secretary of State.
If you're going through the process of becoming.
If you're going through the process of creating a co-op, but that's not what I want to ask. Thanks for this information. It's really, really helpful. Maybe I missed it, but if a co-op wants to be nonprofit so that it doesn't have to pay taxes on grants, how do they do that? And if they already if they're already in a structure that doesn't allow that, can they change their structure? That's what precipitated these questions.
Mm-hmm. So I'm not a tax expert, and I'm really reluctant to go too far down that rabbit hole because it's quite complicated, especially taxation of cooperatives. But again, so I want to draw distinctions between how you organize yourself and on what basis you are text, because as I said, you could have an LLC that is organized as an LLC, but then for federal tax purposes qualifies under subchapter T for cooperative taxation because of the way it structures its ownership, its distributions, and its patronage, dividends, and limits its taxation basically by allowing it all to pass through, most of the earnings to pass through to members based on their activity. Under our law, I really don't think you can organize as a nonprofit and a co-op structurally.
Oh,
Again, this is unclear. This is a real fundamental problem as far as I'm concerned in our law. In some places it says you can have, for instance, like a marketing co-op that is a nonprofit. But then again, like I said, when you want to form one of these things, it refers to creating a corporation pursuant to 11 VSA Chapter 17, and then electing through basically the way you structure your business, the way you write your bylaws to operate according to cooperative principles, check all those boxes in the statute, and you're magically both a corporation and a cooperative. So I don't have a good answer for you. Does it require conversion? Can you convert? Can you be a nonprofit cooperative structurally? I don't think so, but I could be wrong. And the law is not clear. It needs to be clarified.
all right. So clarifying that law should be something that this committee recommends is my takeaway.
That's up to you, of course. That's a
Yeah.
policy choice for legislature.
Yeah.
Go
And
ahead.
Mary
Mary.
has a question.
Yeah, go ahead, Mary.
I having looked into this a little bit, I know nothing about what Vermont law says, but I did find on the internet an article from, I think it was someplace in Michigan or Minnesota, about converting a housing cooperative to nonprofit status for federal tax purposes. And I just remember that they had to be able to demonstrate that 75% of their residents were low or moderate income as part of a process. So it is possible, at least in some states, and it's not easy.
So again, I want to be cautious about conflating the structure and then the tax. So for you to qualify for tax purposes for cooperative treatment, and there are different kinds. So there's the 501c12 for like mutual insurance companies and electric cooperatives and ditch and irrigation companies. They have their own sets. There are farmer cooperatives that operate under yet another set of rules and do have some ability to avoid further taxation. And then there again is subchapter T treatment, which affects sort of your run-of-the-mill cooperative construct. In part, one of the boxes that you have to check is percentage limitations on how much you can distribute back to your members. Again, how much ownership is out there in the world. I mean, federal law doesn't actually, for tax purposes, define what a co-op is. That comes from a common law case from the 1960s. It's whether or not you operate on this basis, and you can check those boxes, affects how much of your income as a co-op is subject to taxation. So in case I've not been clear about that part of it, let me say it again. Let's say you're something like a Sunkist or a business that's running as a co-op. And again, we're talking about levels of taxation. Does the co-op itself have to pay? Do the owners have to pay? Do both have to pay? It depends on what kind of money or where the source of the income is. So again, if the co-op, if the entity is earning money based on patronage or engagement, business transactions with its member owners, then that's basically not going to be taxable, right? If it's earning money from somewhere else, non-patron revenue, that is taxable to the business. The co-op doesn't have to pay tax on patron-based revenue. It just passes it through to the patron members. But that is taxable for the member owners. So it's a misnomer to say that a co-op is a nonprofit, because it is, the income that it earns is taxable at one place and sometimes both. But it just depends on what the character of the revenue is. Versus a nonprofit corporation is, first of all, structured usually as a nonprofit under some sort of state law. And then it goes to the IRS and it says, we are formed for a qualifying exempt purpose. We are operating on a nonprofit basis. And here's our purpose and here's our ownership structure. And will you qualify us to be a federal nonprofit? A nonprofit actually would have to pay tax if it has too much unrelated income. If it takes on some sort of a side business, or it starts selling hats just to raise money for kids, but then all of a sudden the hats go viral and they're selling 10 billion hats a year and they're making all this money. Some of that money revenue could be taxable, even though it's organized as a nonprofit, even though it's qualified as a nonprofit for the purpose of the IRS. So I don't want to conflate those. There are cases where cooperatives pay less tax often. The entity itself can pay certainly no tax, but it is not a nonprofit in the sense of a 501c3 organization approved for nonprofit status by the IRS.
Okay. Gail, did you question, Gail?
That was exactly my question, was the difference between the 5013C and the other nonprofits. And you just answered the question.
Sure. So there are even more of those. Under 501c, there are like 20, I don't know how many different kinds of organizations that will qualify one way or the other. But again, you have to check whatever boxes in that law. The last thing I'll say about taxes, because it did come up on your sheet and I forgot to mention it, is for a corporation, and I'm talking about a for-profit corporation, for tax purposes, there are different kinds. There's the C and there's the S. And the S is the closely held, and that is typically a pass-through type of taxation, like a partnership where the entity is disregarded for tax purposes and the income and profit is attributed to the owners of the S corporation. So that is a tax construct, not an organizational construct. If we wanted to form a corporation, on the formation side, we would come to my office and file articles of incorporation, and then we would operate under Title 11A for our organizational purposes. We would have to form a board. We'd probably hire a CEO, and then if we made money, if we're a C corporation, this is on the tax side, if we're a C corporation, our company would have to pay a corporation tax on the revenue and the income. And then if it gave us money as individual owners, we would pay that as part of our ordinary income. An S corporation, you'd go through the same formation process, but then you'd have it'd be smaller. You could disregard the board of directors, and you could choose to be treated under the subchapter S of the Internal Revenue Code, and it would disregard the entity, and we would just pay taxes as individuals. All of that revenue would pass through. That's the so-called partnership taxation that I talked about at the beginning. But that, again, is the fundamental difference between organization and tax.
Okay. Again, I will put out a link to his testimony. So if you want to go through it again and pick through it, you can, to better understand how all this works, which is what I will end up doing. It's available. So that in a couple of days or so after the meeting. Any more quick questions? We need to wrap this up and have our break. Okay. Thank you very much, David.
Glad to be here. I know that's a lot of information, and when you do go back and listen to it, probably I will have said something wrong, and I'm happy to correct mistakes I made and answer any follow-ups you might have.
If nothing else, it shows us how complex the ownership of mobile home parks can be. So,
It can be. Nice to see you all.
okay, thank you much. And we'll take a break now for about 10 minutes. We'll see you at